Probate is quietly taking homes away from American families this month, and most parents over 60 have no idea it is about to happen to theirs. The average probate case in the United States now runs between 3 and 7% of the total estate value, which, on a $400,000 home, can wipe out $28,000 in court fees, attorney costs, and executor commissions before a single child inherits anything. But the money's not even the worst part. Probate can freeze a family home for 6 to 18 months, force a sale the children never wanted, and in a growing number of cases, hand the deed to a relative nobody planned on. 7 specific mistakes are behind almost every one of these probate disasters, and every single one of them can be fixed this week at a kitchen table for under $200. There is one mistake on this list that almost every parent makes without realizing it, and by the time a family discovers it, the home is already in the hands of the court. Stay until the end, because the last mistake on this list is the one that decides whether the house leaves the family at all. Now here's where it gets serious. Probate is not a penalty. Probate is a legal process that every estate goes through when a person dies without the right documents in place. Therefore, the mistakes on this list are not about what a family did wrong on purpose. Every one of these mistakes comes from a piece of paperwork that was missing, outdated, or filled out the wrong way decades ago. Mistake 1. Relying on a will alone. Most parents believe that having a will protects the family home. Therefore, when they die, the children will inherit the house without any fight. But a will is the exact document that sends the house into probate in the first place. When a will exists, the court reads it, validates it, and then supervises every transfer of every asset listed inside it. On a $300,000 home, court costs, filing fees, appraisal fees, and attorney fees commonly add up to between $9,000 and $21,000, depending on the state. In some states with complex probate systems, the total has reached $40,000 on a single home. The home is also frozen during the process. The children cannot sell it, cannot refinance it, cannot even rent it out without court permission, which commonly takes 45 to 90 days to obtain. The mortgage still has to be paid. The property taxes still come due, and the insurance still needs to be maintained. If the family does not have the cash to keep paying on a frozen house, the lender can start foreclosure proceedings before the probate case is even finished. The fix is a revocable living trust. A living trust is a document that holds the home instead of a will, which means the home never goes into probate at all. The trust costs between $1,500 and $3,000 to set up with an estate planning attorney, or under $200 for straightforward estates using an online estate planning service. Therefore, on any home worth over $100,000, the trust pays for itself several times over the first time it is used. Mistake 2. Creating a living trust and never funding it. This is the silent killer of American estates. A family pays $1,500 for a beautiful trust document, signs it at the attorney's office, and then drives home thinking the house is protected. But a trust only controls what has actually been transferred into it. Therefore, if the home is still titled in the parent's personal name on the deed, the trust is worthless the moment the parent dies. Industry studies from the estate planning field have consistently found that more than 60% of living trusts in the United States are unfunded or only partially funded. That means the majority of families who paid for a trust will still end up in probate court because the house was never retitled into the name of the trust. Funding a trust is one extra step. The parent signs a new deed that transfers the home from their personal name into the name of the trust. The new deed is recorded at the county recorder's office for a filing fee that commonly runs between $15 and $100, depending on the county. That is the entire process. But if that single step is skipped, every other protection the family paid for collapses. There is one warning here. Transferring a home into a trust can sometimes trigger a due on sale clause in the mortgage, which gives the lender the right to demand the full balance at once. Federal law, under the Garn-St. Germain Act, protects most transfers into a revocable living trust for a primary residence, but the rules can be more complicated with rental properties, investment homes, and second homes. Therefore, a parent who owns more than one property should always confirm the transfer with the lender in writing before recording the new deed. For any parent who already paid for a trust, the question to ask tonight is simple. Pull the deed on the home, look at whose name is listed as the owner, and if that name is not the trust, the home is not protected. Mistake 3. Naming the wrong person as executor. The executor is the person who manages the estate through probate and handles every decision about the home until it is transferred to the heirs. Most parents name their oldest child out of tradition, or they name the child who lives closest, or they name the spouse without a backup. But the executor role is one of the most stressful financial jobs in American law. Therefore, picking the wrong person can stretch a 6-month probate into a 3-year war. When an executor is unprepared, disorganized, or in conflict with other siblings, the probate process grinds to a halt. Court hearings get postponed, paperwork gets filed late, and every delay costs the estate money. Attorney fees for a contested probate regularly climb into the $25,000 to $75,000 range. And those fees come straight out of the value of the home, before any child inherits a dime. There is a second risk most families never think about. If the named executor dies before the parent, or is unable to serve when the time comes, and no backup executor is named, the court appoints an executor on its own. Court-appointed executors are often attorneys who charge statutory fees, which in some states run as high as 4% of the gross value of the estate. On a $400,000 home, that is $16,000 paid to a stranger who has no connection to the family. The fix is to name a primary executor and at least one backup in writing, and to tell the named person they are being chosen before the documents are signed. An executor who is surprised at the funeral is already behind schedule. Therefore, every parent should have a 15-minute conversation with the named executor about where the will is stored, where the deed is stored, and who the family attorney is. That is 3 mistakes in, and the running total is already sobering. Between probate court fees, a disorganized executor, and contested attorney bills, the first 3 mistakes alone can drain $50,000 out of a single home before a child inherits anything. But the next mistake is the one that can quietly erase every other protection a family has in place. Because it does not matter how carefully a will or a trust is written, if the deed itself is worded the wrong way. Mistake 4. Joint ownership without right of survivorship. When 2 people own a home together, the deed usually lists them as joint owners, but the exact wording on the deed determines what happens when one of them dies. Therefore, 2 homes with nearly identical deeds can end up in completely different places after the first owner passes away. If the deed says joint tenants with right of survivorship, the surviving owner inherits the home automatically, outside of probate, the moment the first owner dies. But if the deed simply says tenants in common, or just lists both names without any survivorship language, the deceased owner's share goes through probate like any other asset. That share can be inherited by a child from a previous marriage, by a sibling the surviving spouse has never met, or in some cases, by the state itself, when no valid will exists. This happens most often in blended families, in homes bought decades before the current marriage, and in homes that were refinanced without a matching update to the deed. Many families discover the problem only after the first spouse dies, when the surviving spouse learns they do not fully own the home they have lived in for 30 years. Consider a common example. A husband and wife buy a home together in the 1980s. 30 years later, the husband passes away first. The wife assumes she owns the home outright because her name has always been on the deed. But when she visits the bank 6 months later to refinance, the loan officer tells her the deed only passed her half of the home automatically. The husband's half went through probate and was divided among his 3 adult children from a first marriage, according to the default inheritance rules in her state. One of those children now legally owns a piece of the house she lives in. If that child later sues for partition, the court can order the home to be sold, so every owner can collect their share. This is not a rare scenario. Probate attorneys see a version of it every single month. The fix is to pull the current deed, read the exact ownership language, and if the words right of survivorship or tenants by the entirety do not appear, file a new deed that corrects the wording. The filing fee at the county recorder's office is commonly under $100. In most states, a real estate attorney can prepare the corrected deed for between $200 and $500. Therefore, the fix is one of the cheapest protections on this entire list. Mistake 5. Outdated beneficiary designations on retirement accounts and life insurance. Beneficiary designations override the will every single time. Therefore, if the will leaves everything to the current spouse, but the life insurance policy still names an ex-spouse from 20 years ago, the ex-spouse gets the money. No court, no argument, no appeal. This is the mistake that quietly destroys families after a second marriage, after a divorce, and after the death of a child. Industry reviews of the life insurance sector have estimated that billions of dollars are paid to unintended beneficiaries every year because the policy owner never updated the form after a major life change. On retirement accounts, the problem is even bigger. A traditional retirement account with an outdated beneficiary designation can be paid out in a single lump sum to someone the family never intended. And that lump sum can trigger a federal and state income tax bill that wipes out close to 40% of the account value in a single tax year. The fix takes 30 minutes at the kitchen table. Pull every life insurance policy, every retirement account statement, every annuity contract, and every transfer on death bank account. Look at who is listed as the primary beneficiary, who is listed as the contingent beneficiary, and whether any of those names belong to someone who has died, divorced, or fallen out of the family. Call the plan administrator, request a new beneficiary form, fill it out, and send it back certified mail. Every update takes one phone call, but the consequence of skipping this update can be a child cut out of hundreds of thousands of dollars, while an ex-spouse they have never met walks away with the retirement account. Mistake 6. Never updating the estate plan after a major life event. Estate plans are not a one-time document. A will or trust that was drawn up 20 years ago almost never reflects the family as it exists today. But most parents sign the documents once, file them in a safe, and never look at them again until the day they are read out loud at a funeral. Every major life event is a trigger that requires an update. A divorce, a remarriage, the birth of a grandchild, the death of a spouse, the death of a named executor, a move to a new state, a sale of the original home, a purchase of a new home, and in some cases, a change in federal estate tax law. Therefore, an estate plan that has not been reviewed in 10 years is almost certainly out of date. The biggest risk is a move to a new state. Estate laws can vary significantly from one state to another. Community property rules, homestead protections, probate thresholds, and spousal inheritance rights can all change the moment a family crosses a state line. A trust that was perfectly structured in one state can have a loophole the moment it is administered in another. The fix is an annual review. Once every 12 months, pull the estate documents out of the safe, read them from front to back, and check whether every name, every asset, and every instruction still matches the family as it looks today. If a single detail has changed, schedule a 1-hour consultation with an estate planning attorney. A review appointment commonly runs between $200 and $500. Therefore, the total cost of keeping an estate plan current for 20 years is less than the cost of one contested probate case. Before the final mistake, there is one rule that ties every item on this list together, and most families only learn about it after it is too late to use: the 5-year Medicaid Lookback rule. When a parent applies for long-term care Medicaid, the state reviews every asset transfer made in the previous 5 years. If the home was transferred out of the parent's name within that window, the state can treat the transfer as disqualifying and require the family to pay the full cost of care before Medicaid covers anything. Nursing home care in most of the country now runs between $8,000 and $15,000 per month. Therefore, the timing of every fix on this list matters as much as the fix itself. The safest path is to build the full plan early, while the parent is still healthy, and years before any medical crisis forces a rushed decision at the worst possible moment. Now, here is the final mistake, and this is the one that decides whether the home stays in the family at all. Mistake 7. Letting the house pass through probate in the first place when a simple deed could have kept it out. This is the mistake almost every American family is making right now, because almost no one over the age of 60 has been told that a deed exists that can transfer a home directly to the children without probate, without a will, and without a trust. The document is commonly called a transfer on death deed, and it is currently recognized in roughly 30 states under various names. To understand why this deed matters, consider what actually happens when a home enters probate. The family files the death certificate and the will with the local probate court. The court opens a case file, assigns a judge, and posts public notice to creditors. Creditors have a window, commonly 3 to 6 months depending on the state, to submit claims against the estate. The executor then has to inventory every asset, collect every debt, pay every bill, and file regular reports with the court. Only after every creditor is paid, every tax return is filed, and every objection is resolved can the remaining assets be distributed to the heirs. In an uncontested case with an organized executor, that entire process commonly takes 9 to 18 months. In a contested case, it can stretch past 3 years. Every one of those days is a day the family cannot sell, refinance, or even fully occupy the home without court permission. A transfer on death deed works the same way a beneficiary designation works on a bank account. The parent signs a simple form, names the children who will inherit the home, files the form with the county recorder, and then continues to own and control the home exactly as before. The deed only takes effect the moment the parent dies. At that point, the home transfers directly to the named children automatically, outside of probate, with no court involvement at all. The filing fee commonly runs between $20 and $100. An attorney can prepare the deed for between $100 and $300. And in many states, the form is available at the county recorder's office for no cost at all. Therefore, on any home in a state that allows this deed, the total cost of bypassing probate can be under $100. But most parents have never heard of this deed, because the attorneys who benefit from probate have no incentive to explain it. This is exactly why I put together a free checklist for families who want to protect their home from probate before the end of this year. The checklist walks through every one of the 7 mistakes in this video, but it also covers the 3 core documents that must be in place for the fix to hold up in court, the exact language that needs to appear on the deed, the deadlines that trigger a forced sale if they are missed, and the 5-year Medicaid Lookback rule that can undo every protection if the timing is wrong. It is a printable document. It is free. It is the same kind of checklist that a family would commonly pay an estate attorney several $100s to walk through in a consultation. Therefore, it is the fastest way to find out tonight whether the home is actually protected or whether the family is one court filing away from a probate disaster. To get it, go to mark-callaway.kit.com/checklist and enter the email address where the checklist should be sent. It arrives within 1 minute. There is nothing to buy, nothing to sign up for beyond the email, and no obligation of any kind. Print it, take it to the kitchen table this weekend, and go through it line by line with whoever in the family will inherit the home. One conversation this weekend can protect everything the family has spent a lifetime building. 3 final steps to take this week. First, pull the current deed on the home from the county recorder's website or office and read the ownership language out loud. If the words right of survivorship, tenants by the entirety, or trust do not appear, the home is exposed. Second, pull every life insurance policy, every retirement account, and every transfer on death bank account, and write down every beneficiary name on a single sheet of paper. If a name on that sheet is an ex-spouse, a deceased relative, or anyone who is not supposed to inherit that money, update it this week. Third, confirm that a named executor exists in the will. Confirm that a backup executor exists, and confirm that both of them have been told they are being chosen. An executor who is surprised at the funeral is already behind schedule. Do not wait for a diagnosis, a hospital visit, or a family emergency to force the conversation. Probate is not something that only happens to other families. Probate happens to every family that has not taken these steps, and it is already costing American parents billions of dollars every single year.